which confirms my position that what the Department of Health is doing now should go through a rulemaking process, because this is a substantial change from the way the registry has been run now. There has been no contemplation of data sharing in the past 2 years.
Any other questions or comments? Anyone on the phone? Thank you very much. Are you planning on staying around while we may ask you to come back? Joan, did you have something?
I do have a question.
Go ahead, ma'am.
So, how you expressed your concern about the 12 by 12 square with all of the data in there with the Department of Revenue. How does this proposal affect that?
This proposal would merely says that the Department of Health is not allowed to share any information with the Department of Revenue.
I understand that. But your concern is that the Department of Revenue is going to require each of the patients to voluntarily give all that information.
Yeah, that's a separate concern that we're taking up with the Department of Revenue on, with our petitions to them.
You understood that. Okay, great.
No, I understand the agency delineation here. What's happening is that the agency, what Matt Cook has said is that the registry is going to be replaced. That is what he has told us multiple times in the past at multiple public meetings, that the registry, the confidential registry, is slated to be replaced by a registry that he wants to run through the Department of Motor Vehicles, through the Department of Revenue, that the new patient ID cards will be issued through the Department of Motor Vehicles, through the Department of Revenue. Now, what he has also said in the past is that this will require patients to give up their constitutional right to confidentiality, to buy cannabis at a medical marijuana center. Once again, in the same way that the Department of Revenue has created this statutory privilege of owning a medical marijuana center and providing for patients, and not letting those centers call themselves caregivers anymore, and taking away those centers' constitutional protections, they're taking away the constitutional protection of privacy for the patients and saying that if you want to shop at a medical marijuana center, you're going to have to surrender your constitutional right to privacy and go into our system with our ID card and our everything and the cameras and the film. And that in that way, the Department of Revenue is trying to subvert the Constitution. I'm glad that we have made you aware of this issue, and I really hope that you will work your hardest to preserve the confidentiality of the registry and avoid any issues.
Thank you. Are there other questions? Ma'am, thank you again for that. I think before we go any further, I just need board discussion.
So, point of clarification. On our agenda, this is noticed as a briefing.
No, it's agenda item 8.
Oh, wait, consideration of the petition. So, I'm sorry, I was just briefing and then.
This is a consideration of a petition. The main option is whether or not we vote to accept the petition. If we vote to accept the petition, then it would be scheduled a rulemaking hearing, much like any other petition coming from the department or anyone else. So, I suppose you could always write us the hairs, but the main option is whether the board wants to accept the petition or not. So that's the first question. And the next question is, if it's accepted, when is it going to be noticed for a public rulemaking hearing? Did I say it right?
Yes.
Okay. So, do you want to elaborate?
No, I think that's exactly correct.
Or do you understand?
Well, okay, so, so this board, what are the parameters under which this board should consider whether we accept a petition or deny a request for a petition? Are there general rules or general law about how a board like ours make the decision?
I mean, the APA doesn't set forth what factors you should consider other than, what we just heard, briefing, the presentation, and then vote whether or not to accept the petition or deny.
There aren't any. It's certainly the board's discretion to do that. And yeah, I'm going to say, as someone who voted for the constitutional amendment in 2000, I am extremely concerned about privacy of people who are on the registry.
Thank you.
That doesn't mean that we're the right forum to consider that issue. And I know that sounds like a gigantic punt, but the problem is, we've heard concerns about breaches, theoretical breaches, on a system that doesn't exist yet. And we've heard that Department of Revenue may do something, or maybe it won't. This board, in my opinion, lacks statutory authority to tell the Department of Revenue to do anything. And if there are, in my opinion, the kinds of breaches of privacy that do occur, the laws of this state in the United States require an injury before there's something redressed. If there are those kinds of, as I said last meeting, and I say in this meeting, I believe the courts of the state are the proper avenue, and not to get into an internecine spitting contest between Department of Health and Department of Revenue on who's going to trump who. My concern is, even if we considered these regulations, they wouldn't be authorized. They would have no legitimate basis, in my opinion, under the statute. That's my concern. Laurel.
I concur with that, and I think, again, I'm sympathetic. All of us are concerned about confidentiality and upholding what the Constitution said and what our statutory authority is and what we're expected to do. And I appreciated the briefing that we had, because this is new. There's a lot of different agencies involved in this, and I think it's important to delineate those responsibilities. And while I do understand the concerns that are being brought up, I think it's difficult, as Glenn has said, to try and, I think, apply anything to the situation at this time, because there isn't any change being proposed to the existing system. There may be, there may not be, and I think the important thing is that we monitor the situation. But at this juncture, I'm confident that we do have, as is we're required to have, a confidential registry. It is in place, it is working, and it is not, thus far, to my knowledge, been breached. And until there's a proposal otherwise, I think it's premature to consider this petition.
Joan?
I'd like to hear from Jennifer on what you just said earlier about you thinking that if we did adopt a rule, it wouldn't be upheld.
But what I said is, if we adopted a rule, I think it would be doubtful, in my opinion, that there's a statutory basis for our adopting that rule, or if we were to actually adopt this. You get 10 lawyers in the room, you'll get 10 different opinions. But
well, and I think your point also was that some of the concern is whether or not the statute is in violation of the Constitution, and that is something that the court should address, not the Board of Health. I mean, if the statute's going to be challenged, it will, and that's. Does that make sense?
Well, I think you came at it a different angle. I think Joe just asked you straightforward. We have the authority under the enabling acts that enable the Board of Health to do stuff, to pass a regulation that restricts what the Department of Revenue can do.
Oh, absolutely not. Yeah, there's no authority.
I think what I was asking would be, could we adopt a regulation that would say that we would not share information with the Department of Revenue?
Sure, let me get the exact.
Freeho was really focusing on item 1 and item 2 in her proposal.
I don't. The authority given to the Board of Health is pretty broad. For rulemaking authority to enact, rules of administration, establishment